All right.
All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States in this honorable court. This honorable court is now in session. Please come to order.
Good morning and welcome to the District of Columbia Court of Appeals for our virtual oral arguments on this Zoom platform. In light of the coronavirus pandemic, we're conducting our arguments virtually for the safety of all parties and court staff, so thank you. We have two cases set for argument today. Our first case is In Re Estate of William Keough, Stephen Keough, and other parties. And I hope I pronounced the name of the estate correctly. We're joined this morning by Associate Judge Roy McLeese of the DC Court of Appeals and Associate Judge Neil Kravitz of the DC Superior Court, who is joining us and sitting by designation today, and we welcome him. Are the parties ready to proceed?
Yes, Judge.
Okay. Mr. Johnson.
Thank you, Judge Blackburn Rigsby. I am Vernon Johnson from Nixon Peabody, and I represent the appellants on these combined appeals, the estate of William F. Keough and Stephen Keough, who is both William's son and the personal representative of William's estate. I'd like to reserve 3 minutes for rebuttal, if I may.
Yes, thank you.
Thank you. This appeal is being pursued in order to effectuate the indisputably clear and unambiguous testamentary intent of William, as William expressed it in two documents. First, a last will and testament that he signed on November 20th, 1981, and the second, a codicil to that last will and testament that he
Mr.
signed.
Johnson, I'm
Yes.
sorry to interrupt you. I'm just going to ask that we mute our microphones if we're not talking or asking questions, because I'm hearing a bit of feedback as you speak.
Is that better? Okay. And the second document that William signed was a codicil to the last will and testament, and he signed that on August 7th of 1984, actually not long before he unfortunately died. And in protecting William's intent, doing so also has the incidental effect of also carrying out the intent of his spouse, Catherine Keough, who is the heir of his residuary estate. And her estate is pending in the state of New York. And there are some proceedings that I'm not sure would be considered related to this case, but they are relevant to the proceedings before us.
Mr. Johnson, can I just interrupt for a second? I mean, I think we all recognize what the will says and what the codicil says. But it seems to me that it's still quite speculative to think about what William Keough would have decided to do with this $4.4 million had he known that he was going to have it, or that at some point it was going to come into his possession or into his estate's possession. He made a decision, presumably back in 1981 and then in 1984, based on what he had and what he understood he had. How do we know that he would have given nothing to his daughters out of that $4.44 million?
Well, Judge Kravitz, we know that in several ways. Number one, he made an arrangement in his last will and testament for the disposition of his residuary estate. In Article 4th, which you can find at page 26 of the joint appendix, he made an arrangement where he said, anything else that I have basically will go to my wife, Catherine. He also made other arrangements to indicate what would happen if Catherine wasn't able to inherit those assets. And he had several contingent residuary beneficiaries, the last group of which are all of his issue. But he very meticulously made sure that if that situation ever came to pass, Kate, who's the appellee, would not inherit anything, because he instructed that it would be considered that Kate and her other sister Alyssa had predeceased him for purposes of determining those issues. So he was very clear. And when he
Counsel, can I ask you,
of course,
I'm having a question about the framework here about intent, to the extent we think it's relevant, because of the multiple layers of wills involved and because of the substantial passage of time. So let me just give you a hypothetical and see how you think it should be understood. Imagine that in this case, it had been completely clear that Mr. Keogh's intent, as reflected in the will, was, I want all my residual estate to go to my wife if I predecease her. But by the way, I am completely disinheriting child A. The most important thing is that child A takes nothing from me. And then imagine that what happened here happened thereafter, except, so imagine that he passes away, and then imagine that, his wife's will, however, is different. And his wife says, I'm going to give everything to the child that Mr. Keogh wanted to disinherit. And then, 10 years after she dies, Mr. Keogh's estate comes into possession of $4.4 million. What's supposed to happen with that? We would know in one way of looking at Mr. Keogh's intent, it would be, well, I definitely want, that child to be completely disinherited. And so I would not want that $4.4 million to go to that child. But on the other hand, the way the will was written, all of the residual estate went to the wife, and the wife ended up choosing something very different from what Mr. Keogh had wanted. And she wants to give all of it to the child that Mr. Keogh intended to disinherit. Like, whose intent are we supposed to be looking at? Or how would you conceptualize a case like that?
well, for purposes of this case, Judge McLeese, we're looking at William's intent. William expressed it clearly and unambiguously, and nobody disagrees with that.
Well, I'm not sure. I don't mean to interrupt, or I guess I do mean to interrupt, but could you answer what should happen if those were our facts? Who should receive how should the $4.4 million be allocated if the case were different in in the two respects I've identified? First, it was even clearer that there was an intent to disinherit let's say, daughter Kate. But imagine that the mother's will had kind of reversed field on that and was going to give everything to daughter Kate. Should daughter Kate take, consistent with like the two steps of the analysis, or should daughter Kate not take, because you look to Mr. Keogh's original intent as reflected in the will he drafted?
In your hypothetical, I think William doesn't have any way to control what Catherine does and what Catherine's intent is. So in the proceeding up in New York, they're construing Catherine's intent and applying it. She could choose to leave to whomever. She's not restricted by what William decided to do with his estate. When she's got,
if that's right, I think, I may well agree with you, but if that's true, it seems like it doesn't really matter what the husband's intent was relative to his children. The only thing you need to know is that he wanted all of his residual estate to go to his wife if he predeceased her. That's the only thing. That's the only intent. If given the answer you just gave me, that's the intent that's relevant here. And then the rest of the issues are, well, now you figure out under New York law what New York is going to do relative to after acquired property for the wife. So it seemed like a lot of your answers about or your comments about Mr. Keogh's intent are irrelevant if the only thing that matters is the first step, which is he intended that his entire residual estate, whatever it might be, go to his wife if he predeceased her. Is that right? Or do you actually think that some of what you're saying about what the will reflects about his intent relative to his children should be taken into account by us?
Well, I'm not sure exactly if there's a conflict between what I'm saying and what you're saying, because we've been asking all along that his intent, as set forth in Article 4 of his last will and testament, be carried out. And that says that.
Right. The point where we
Mr.
seem like we
Johnson?
might be disagreeing. Well, go ahead.
I was just going to say, I think I see areas where what you're saying and what Judge McLeese say really converge with respect to looking at intent. But I wonder if I could ask you to look at the language of the statutes that we're dealing with here and where they come into play. I mean, it seems that the trend in probate law is clearly moving towards a trend of, and has been over time, of disposing of property through a will, if possible, and avoiding intestacy. And we have DC Code 18-305, which is referenced in the parties' briefs, that does talk about after acquired property. The trial judge defines after acquired property slightly more broadly than this 18-305 statute does. There's property acquired after a will is executed, but before the testator dies, and property acquired after the testator dies. Is that distinction relevant here? This $4.4 million was acquired by the estate after Mr. Keogh died. It was also acquired after the will was executed. Our statute stops at property acquired after the will is executed. It's silent as to what to do about property acquired after the death of the testator. Does that silence matter here? Could you also talk about what we do with the language from the Uniform Probate Code?
Sure. So I think that the issue here is that there is a code section 18-305 that really was designed to address real property. And I think there's a reason why it makes sense that it only addressed real property, because over time, historically, the way that the probate code in DC has dealt with real property has been very specific. For a period of time, it was only the personal representative who could take title and could convey title. And there were a lot of different procedural requirements for that. But I think overall, if you look at the cases, the district has never applied a hard and fast rule that says property acquired after death can't be passed through a will. That's never been the law. And the 1825 case that we cited, United States versus Baker, is an example where that issue should have come up if it was a concern, and it didn't. Now, there are not a lot of cases that deal with this specific issue, but there are many, many cases that deal with carrying out the testator's intent and following the will if we can.
Right. Right. Can I stop you right there? Like, yes. I agree with you. Our research did not uncover any cases exactly on point interpreting 18-305 or interpreting or clearly defining what after acquired property means. And in light of that, I guess I don't see anything that precludes us from interpreting the after acquired property here in such a way that would allow it to pass through the residuary clause of the will. We also have another provision in our code, which neither party referenced in their brief, 18-301, which says that the real and personal estate of a person, which may pass by deed or gift, or which would, in case of the owner's dying intestate, descend or devolve upon his heirs or other legal representatives, may be disposed of, transferred, and passed by his last will and testament, or codicil. And it seems to me that reading that in conjunction with 18-305, and in the absence of any clear common law to the contrary, would allow us to pass the property through the will as opposed to, and avoid intestacy, which is what our policy and thinking generally is in the area of probate and estate law. And it seems to be where many other jurisdictions are headed. And it's clearly where the Uniform Probate Code is taking us, I think. Could you comment on that?
Yes, I very much agree with what you're saying. And I also think that historically, it's significant that there's no instance where in the District of Columbia, in a situation like this, the Court of Appeals or any other court that binds District of Columbia in terms of the law has ever said there's a hard and fast rule that says you can't provide for the disposition of property that you acquire after death. And like I said, the United States versus Baker case is the closest we could come. And that certainly is a case where that issue should have come up, because the wife died in 1819 and the property was coming into her estate in 1822, and they were figuring out a disposition. And admittedly, it's probably unusual to go all the way back to 1825 for precedent, but Judge McLeese wrote the opinion last year in the Gann versus Van Buren Street Methodist Church case, where we went back to 1920 to find a attacking adverse possession decision that does bind District of Columbia from the Court of Appeals for the District of Columbia. So it does happen. And
well, are you suggesting that Baker binds us to an answer favorable to you? Because when you just mentioned it initially at argument today, you seem to be making a weaker argument, which is if there were a flat rule that, you know, posthumously acquired property can never be transferred by will, then you would have thought someone would have said something about it in Baker. That's one kind of an argument. That's not sort of that Baker holds that the answer to this question is one thing or another. It's more of that's kind of some negative evidence, some circumstantial evidence about what the rule might or might not have been, or at least that there wasn't a clearly established rule. So which is it? Are you claiming that Baker actually has committed the District of Columbia already to the binding conclusion that after acquired personal and real posthumously acquired real and personal property can be transferred by will?
Well, Baker doesn't address the question clearly and directly for certain, but Baker does say that in order to determine the distribution of the assets of the decedent, distribution is, quote, as they would have been on the day of his death when the rights of the distributees accrued. So that certainly does suggest that for purposes of this case, for William's estate, you would go back to his date of death and determine who had the right to inherit, and that's Catherine under the Article 4th of the last will and testament. So in that sense, I do think that is binding authority in the District of Columbia, that's where you look at the point in time in order to determine who the heirs are. And I agree with Judge Blackburn-Rigsby that the trend certainly is that we try to follow the will and avoid an intestate distribution if we can, because an intestate distribution doesn't at all reflect the intent of the testator. It's some sort of a approximation the appellee has claimed, or it's an indication of what his intent is presumed to be. It's none of those things. It's just a way of dealing with things if there is no testate provision for it. And we don't have that here. We have a will that was very carefully done, and I would say very meticulously done in terms of how he designated who his heirs would be. And primarily he wanted the residuary estate to go to Catherine, but he also made very careful, specific arrangements for what would happen in the alternative to that. And he arranged that Kate, the appellee, would not inherit anything under those circumstances as well. So I think he was very clear.
I do keep getting hung up on why that's relevant. It doesn't seem to me on the logic of your argument and your answers to my questions earlier why that's at all relevant. He expressed an intent that his residuary estate go to his wife if he predeceased her. That seems like it's all that matters for our purposes. If it's allowable for him to do that with respect to property of this kind, and if that language covers property of this kind, then why does it matter what his intent was with respect to other scenarios that never came to pass? The issue then would just be, okay, well then, if we're going to effectuate his intent, that's the relevant intent. The rest of it was like counterfactual, hypothetical things that never happened. And then it goes off to his a set of issues under New York law about what's going to happen with respect to his wife's will and posthumously acquired property and her testamentary intent. And that's all going to be a set of questions at a second level by a different jurisdiction doing a different inquiry.
And that jurisdiction has decided those issues, by the way, but I agree.
Well,
with
it's in the process of deciding them is maybe a fairer way of saying it. There's a trial court ruling and an appeal. I gather that's going to be argued next month.
Yes. But Judge McLeese, I agree with you that the primary issue is his intent, and that's expressed in Article 4th. And that's
I guess where I'm not sure we agree is you're saying primary. Your answers at times seem to logically suggest only. So I'm a little unsure whether you think that's the primary issue or the only issue. But
we are comfortable saying that's the only issue. The point in our getting into what he did in terms of the contingent beneficiaries of the residuary estate is to address the argument from the appellee that the intestacy statute is some approximation of what his intent would be. We know that wasn't his intent.
All right. I'm sorry, Judge Kravitz, did you have another question?
I did, if it's okay.
Sure.
Mr. Johnson, I wanted to ask you about another statutory provision that, unless I missed it, was not cited in the briefs. And this is DC Code Section 18-303, entitled General Devise and Bequest of All Property. And it says a devise and bequest purporting to be of all real or personal property or both belonging to the testator includes also all property of either or both kinds, respectively, over which he has a general power of appointment, unless a contrary intention appears in the testamentary instrument containing the devise or bequest. Does that provision have any application to our consideration of these residuary or the residuary clause in Mr. Keogh's brief in his will?
Well, I think it does, to the extent that there was any question that his residuary clause was intended to pass personal property like the asset that is coming in from the Hostages Act. To me, that's the only way that could be relevant, but I don't think there's any dispute about that. I think the argument
isn't there a dispute over whether at the time he wrote his will or his codicil, he would have had a power of appointment over those funds that he knew nothing about and didn't come until 30 years later?
Well, we don't agree with the premise that he didn't know anything about them, but there is a dispute. And as I understand it, the argument that's being made is that regardless of anything else, there's an overall common law rule that says that you can't pass property through a will if it's acquired after your death. And that's the rule that Judge Pittman applied. And that's what we believe is the reversible error that this court should reverse and come to a contrary determination.
All right, thank you, Mr. Johnson. I know we took you over your time with our questions, but we'll still reserve your 3 minutes for rebuttal. Mr. Recio, is that the correct pronunciation of your name, Mr. Recio?
Fine, Your Honor. Yes.
All right, thank you.
May it please the court, Carlos Recio for Kelly Kate Keogh, who is the sister of Stephen, or one of the sisters. I would like to, no one's talking about the common law rule, and there's no serious dispute that the rule in Great Britain, in Maryland, the common law of any state that is a common law jurisdiction, which is basically all states except maybe Louisiana, is that there is no testamentary capacity, no power over assets that don't exist at the time of death. The rationale of the rule is sound, and that is you can't intend to convey what you don't even know you have.
See, I guess I'm not sure I understand the rationale that well. So let me just ask you what the reason should be. I mean, imagine I'm writing a will and I have, two children, and one of them, I don't know, attempted to kill me. And so I, absolutely intend to disinherit that child. And I want to make sure that child never takes anything from me. And I write a will and I say, here's my, last will and testament. My most important testamentary intent is that, child A never take anything from me again. Try to take my life, didn't succeed. I'm giving that child nothing. All my assets, everything, whatever I get, whatever I might get, whatever anything that I could possibly imagine, anything I can't even possibly imagine. My main objective in life is to make sure that nothing passes to that child. That's my plan. And all of it will go to the other child. Why shouldn't I be able to achieve that? And it seems like the flat rule that says you just can't devise through a will property that doesn't I don't own in some sense of the term at the time of the time that I die, is I can't do that no matter what my desires are. If there comes a piece of property, whether foreseen or unforeseen, if it's a flat rule, I just can't. It'll have to pass through intestacy, and half of it's going to go to the child who tried to kill me, no matter what my purposes are. Why should that be? Why shouldn't I be able to overcome the effect of intestacy with respect to either foreseeable property I don't yet own or unforeseeable property I don't own? If I say, I know I can't foresee everything, but here's one thing I can foresee: no matter what property I get, I'm not going to want to give it to that child. Why shouldn't? What's the policy that should make that flatly impermissible?
Judge McLeese, your hypothetical is an interesting one, and you can construct a lot of interesting hypotheticals. And for that reason, some of the cases in dicta that have considered it have said, except that the common law rule applies, except where there is clear language of an intent to dispose, or in your hypothetical, not dispose of future acquired assets in a certain way. So you can construct hypotheticals. The issue arises very rarely.
Well,
And
how
there's
about,
not that many cases.
if I could interrupt briefly, Mr. Riccio, I apologize, just to add another slight twist onto Judge McLeese's hypothetical. I heard you say that the common law, words to this effect, intends that you not be able to, as a testator, pass on property or will property that you don't know about. And what about a situation where at the time of the execution of the will, the testator actually owns property that was inherited by him from a distant relative? He just didn't know about it. And it's not mentioned in the will specifically. It exists, he owns it, and it's discovered later after the will is executed, after he dies, however you define later. Why shouldn't, in that instance, the property, not specifically known to the testator, but owned and he had a clear interest in, pass through the residuary clause of the will? If I understood what you were saying, in that situation, the property would still have to be disposed of through intestacy.
No, the common law rule is a bright line rule. If you own the property at death, it passes through the residuary clause of the will, assuming the right language in the residuary clause.
I thought that wasn't the common law rule with respect to real property, and that 18305 revised the common law rule with respect to real property.
Correct. And the fact that Congress in 305, its predecessor, changed the rule as to real property to make it clear time of death is the determining factor, but did not change the other common law.
Can I ask you, why do you think 18305 makes it clear that time of death is the determining factor? It doesn't refer to time of death.
It refers, but if you look at the legislative history of it, and I've cited Bradford v. Matthews, the 1896 Court of Appeals case, U.S. Court of Appeals case, that discusses it. That was the exact intent of the statute, along with others. Change the common law rule.
So just to be clear, your interpretation of this provision is that 18305 is that if I am a testator and I, I expect that, 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 I exp I am going to, get real property, and I'm going to get it any day now. And in my will, I write a will like a week before I die that says I, intend to pass this real property along to other folks in the following way that's different from intestacy. The way you read the provision, if as things bear out, I come to be the actual owner of the property the day before I die, then it can pass pursuant to the will. But if no, even though it was my plan and expectation that I was going to get the real property, and I specifically refer to it as something that I am, intend to pass along. The time of death is the kind of the magic moment, and no matter what my intent was, it passes through intestacy if the real property becomes mine, is owned in whatever relevant sense you think that is required here, the day after my death.
That is a correct statement of the law and of the common law. You could apply an exception, such as your hypothetical about the testator who intends to disinherit a child and makes it crystal clear, where you could apply that intent. In dicta, some courts have said that. The case has never actually arisen. But the point on these facts, there is no indication that
To be clear, is your position, I mean, you say that courts could do that. Is your position that we should not, and we should have a flat rule? Or do you think that the better rule is if the testamentary document is clear enough, it can pass property through the will, or prevent at least the passing of the property through intestacy to someone who the testator wishes to disinherit? Which is your position, we should stick with the flat rule no matter what its consequences would be? Or are you acknowledging that a better rule, and the one that we should adopt, is this can be done, as Judge Pittman assumed perhaps it could be, if the will was clear enough? Which is your position?
The case law on that.
Well, my question is less about case law and more about what your position is.
No, I think that if William had stated very clearly and unequivocally an intent, this court could apply it. However, all he said in the residuary clause, and I'm quoting paragraph 4 on page 26 of the appendix, I give all the rest of my property to my wife, Catherine, if she survives me. Far broader
what
language.
What is equivocal about the word all?
All the rest of my property. And the way that you construe, and this is relevant to what Judge Blackburn-Rigsby raised, and you, I believe Judge Kravitz, about 301 and 303. There's the doctrine that I think is proper to raise, that statutes in derogation of the common law are to be strictly construed. So if you want to go against the common law, or if you want to apply and say, no, the intent overrules, it has to be clear. This testator, who was assisted by counsel, very able counsel, if he intended to dispose of future assets or intended to disinherit a child because he didn't think the child deserved a nickel, it has to be very clear, and it's certainly not. Look at the context here. William Keogh was dying of ALS, a horrible progressive disease. There's no intent to disinherit Kate. That's a construct that they put together. The only child disinherited in his original will and codicil is Stephen, because there's no provision for Stephen. What did William want to do? He had $25,000 of his meager assets set aside for his daughter's education. He writes a codicil, page 23 of the appendix, simple one-page document. Kate has now graduated from college. $5,000 I want for Alyssa, my youngest daughter, to finish college. He's not disinheriting Kate. He's not upset with Kate for graduating from college. He's got very little left. He's a dying man. He knows it. And he's setting aside what little he has for his daughter's education, the rest to go to his beloved wife. What would William have wanted if he had known about a $4.4 million windfall 30 years later? Intestacy gives a presumptive intent, and intestacy provides a very fair result.
But would you agree that intestacy is disfavored where there is a will or where there's a possibility of disposing of property through a will?
Generally speaking, it is disfavored.
Can
But in
I
this
ask
case,
you, I'm sorry, Mr. Mauricio, something you said about the statute and the statutory presumption where the statutes may appear to conflict with or contradict the common law, and that they should be strictly interpreted. If I could point you to the language of 18305, the language to me, which seems clear and which would lead to, I guess, the opposite result that you advocate for here, which it says, see, I'm starting with the language. A will executed after January 1902, which by words of general import devises all of the estate or all the property of the testator, operates as a valid devise of real property acquired by the testator after the execution of the will. And here, this property was acquired after the execution of the will. There's no language in here bookending that after the execution of the will with and after the death of the testator. And so I guess my problem is it seems to me that to reach the result that the trial court did here and that you ask us to affirm requires us to read in additional language into this provision of the statute, where, as you said earlier, we're required to do just the opposite, to strictly interpret the language of the statute.
Judge Blackburn Risby, if you review the Bradford v. Matthews case and the history of that statute, originally enacted by Congress in 1887, and Section A of 305 refers to that. This statute was designed to change the separate common law doctrine that a testator could not transfer real property that he acquired between signing the will and death, and made death the bright line rule. Congress did not change the separate common law rule that post-mortem property that did not exist at death, cannot pass by will. Congress did not address that. That's what the Uniform Probate Code addresses separately, and it has not been enacted in the District of Columbia, nor a majority of states. If you read the Marilyn Monroe case, the Shaw case out of the Southern District of New York, similar events occurred in New York, and the fact that Congress, in this case, changed one common law rule, but did not touch the other common law rule, the one that I asked that this court apply, indicates the opposite, that that common law rule continues to apply. And again, the doctrine applicable here is a statute in derogation of the common law is to be narrowly construed.
And
Can I
the
ask you
common
about
law
your-
that you're referring to that applies to the District of Columbia is which case?
I can, on the derogation of the common law?
Yeah,
I'm
which
sorry.
case is the common law for the District of Columbia that we're bound to follow that you're referring to? I know that there are common law and cases talking about the common law of other jurisdictions, Pennsylvania, Maryland, New York. What is the case, the common law case that sets that rule in place here for the District of Columbia? Because I have not been able to locate it.
There is no case on point in the District of Columbia. There are cases on
In which
point.
case, then we're left with the statutory language, aren't we? As it is.
Well, except that the statute under the law of the District of Columbia, the common law of Great Britain, specifically that of Maryland, as adopted in Maryland, becomes the law of the District of Columbia unless changed by statute.
Right, but your
And-
opponent's argument about the common law is essentially the following, or one aspect of your opponent's argument. And I just want to tell me where you disagree with it. The argument is, well, maybe it's true that the kind of consensus common law approach, if you look at old treatises or you look at such few cases as anybody's been able to locate, was this sort of formalism, absolutely just can't pass property through will if you are not an owner of it at the time of your death, in whatever sense of ownership you have in mind. And there seem to be a little exceptions to them on expectancy interests and various other exceptions. But your opponent's argument is, okay, well, maybe that was the consensus common law view, but there's no pre-1801 Maryland case and no DC case that bound the district to that view. And the issue is now arising, and it's arising in 2021 for us, a little earlier for Judge Bittman. And when we decide that common law question, your opponent argues, this court should not just say, oh, well, what was the old common law rule? Look at what's happening now and figure out what the better rule is. And your opponent's argument is the better rule is the rule that's reflected in the new uniform probate code, and it's reflected in the restatement of property, third. And that's what we ought to do. Leave aside the statutes. That's your opponent's argument about the common law. Where do you think that argument goes awry? You're muted, counsel.
The court is advancing an argument that in effect says this court should legislate, which is basically what the appellant is arguing for. The Uniform Probate Code changes the common law and has been adopted in a handful of states. But what you're saying is—
Well, I guess what's puzzling me is the way you're looking at it. Although there was no case in Maryland pre-1801 that anyone's identified, or in DC, that created the common law for this jurisdiction, it kind of exists as a brooding omnipresence, an abstract, whatever the consensus common law view was, that was the law in the district and in Maryland pre-1801, even though no case ever joined up with that view. And I guess I'm not sure that's the right way of looking at it. Another way of looking at it is that was the consensus common law view. This jurisdiction apparently had never decided whether it was going to go with the consensus or not. And so there is no common law on this issue in the District of Columbia because there was never any binding holding on it. And the sort of general consensus view doesn't become the common law of the District of Columbia until, unless and until a court in the District of Columbia decides to go that way, or maybe, again, if there was a pre-1801 Maryland case. That's, I think, your opponent's conceptualization of it. And again, I'm a little unsure what your kind of theoretical basis is for saying the common law of the District of Columbia is whatever the consensus was, whether there's no case reflecting that consensus. Do you have law that suggests that's the right way of conceiving of this thing?
Well, Judge McLeese, it's an interesting position, but I think respectfully suggests that it's contrary to the DC Code.
To be clear, I'm really not articulating a position. I'm just asking, I'm just asking a question. I'm not taking any position. I'm just asking a question about what I understand to be kind of your opponent's line of reasoning.
But look at DC Code, Judge McLeese, 45-401, that says that the common law, all British statutes in force in Maryland on February 27th, 1801, and all acts of Congress, etc., shall remain in force except insofar as the same are inconsistent with or replaced by some provision of the 1901 Code. So by statute, the common law has been expressly adopted. And to repeat, there's no dispute that the common law rule is that a testator cannot convey post-mortem assets. That common law rule is not in dispute. The fact that it arises very infrequently is true, because how often is it that a testator, that a special legislation is enacted that benefits an estate 30 years later? It's an unusual fact pattern. But the law was that by statute, common law applies. And we know what that common law is. Now, this court has some residual power to change the common law, but I respectfully submit that that's a legislative prerogative and not
Just
that of this
just to
court.
make sure I understand, your position is that when we're trying to figure out whether there is binding common law on an issue that comes before this court, that one part of the inquiry is, well, is there a decision of this court that was interpreting the common law and has told us what the answer is under the common law? That's one inquiry. Another inquiry is, well, if not, maybe there's a pre-1801 Maryland case. And if so, yes, then that'll be binding common law in the District of Columbia. But there's a third inquiry that we should be undertaking, which is even if there is neither of those two things, look to see what the consensus common law view was as of, I don't know, 1801 or whatever date you pick. And that, by operation of the statute, becomes the common law of the District of Columbia, even if no court in the District of Columbia or Maryland has ever so held. Is that your view about how those provisions should be interpreted and
Yes,
applied?
it is.
And I mean,
Yes,
do
it
we,
is.
when
I
you look at
believe
our,
that's-
and when you look at our cases where we try to figure out whether we have a binding, common law rule, so we've kind of already answered the question for our jurisdiction, is that a part of it? Do you see our cases going off and saying, well, okay, we can't find any DC case, we can't find a pre-1801 Maryland case. So what we're going to do is we're going to figure out what the consensus rule was in 1801, and we're bound by that. I mean, is that something we've ever done before, or even an inquiry we've undertaken in our prior cases?
No case comes to mind immediately, but the answer is yes, Judge McLeese. And that's what 401 says. In the case, because the issue of postmortem assets arises infrequently, it's not like there's a lot of law on it. However, there is post-1801 law in the state of Maryland that is persuasive authority, and there's numerous authorities of this court that say that. So it's not like it's an abstract concept that we apply. It's not amorphous, it's not abstract. It's a clear rule, and whenever it's been applied and arises in a common law jurisdiction, the Brahmins case out of Pennsylvania
Counsel,
Supreme
you
Court,
say it's a clear rule, but
Maryland
so
Monroe.
if I am a testator and I give away all my property by will in a residual clause like this one to someone who would be other than what intestate succession would provide for, and at the time of my death, I don't own a particular piece of personal property, or some personal property, like a bequest, but I'm aware of it, and I refer to it in my will. I say, like, by the way, I'm aware that, I am named in somebody's will, and I have a, $100,000 bequest. You're saying that can be passed by will. It can't be passed by will. It can be passed by will if the will is really clear, but not if it's a general residual clause. I'm not sure how clear the rule is, but maybe you can help me with that hypothetical.
Well, I mean, as I said, we can construct a lot of hypotheticals. What you're describing is the Brahmins estate case in Pennsylvania. And the cases allow that if the testator is unequivocal in his will, I know about a bequest from my brother, and I want that bequest to go such and such way, then you arguably could apply it because of testamentary intent, being courts like to apply testamentary intent. On these facts, we don't have any of that. We have a man dying, leaving a few meager assets to his beloved wife. As you pointed out earlier, I think it was Judge Kravitz, there's no indication that William would have wanted to delegate to his wife, Catherine, who would end up with these postmortem assets, which is in effect the construction that the appellant is arguing for.
Why do you say
In other
there's
words,
no
Catherine
indication?
didn't even-
Why do you say there's no indication of that? He wrote a will in which he said, I want all of my other property to go to my wife, and presumably for her to do with as she chooses in her life or by will thereafter. So why is that? That seems like, I mean, I guess it could be clearer for sure. He could have said, and maybe from now on, if we rule your way but we say clear enough wills can overcome this, then a good, person drafting a will have clearer language than a general residual clause. But why isn't that at least some indication of what he wanted to happen with all of his property? Because that's what he said he wanted to have happen with all of his property. And the whole idea of a residual clause is I'm not listing all my property. I may not even know what all of it is. This is what I want done. It's like a catch-all. So why is that not at least some indication of what he wanted to have happen to the property?
Well, because William and his counsel are charged with knowledge of the common law rule and the need to be unequivocal if you want to dispose of some hypothetical future property. The California Court of Appeals case says that explicitly. More important, in this case, William and his wife, Catherine, had lobbied for some compensation, as the court knows. They testified before a congressional committee in 1985, not long before his death. What they were lobbying for, by the way, was for $192 per day, and they actually got $50 per day in 1986 from taxpayer money. This Victims Act arose 30 years later because of fines from BNP Paribas, the French bank. This is something totally unforeseen, totally unexpected, and it awarded $10,000 per day. So, but even then, if William had really wanted post-mortem money to follow, compensation money because he was a hostage of the Iranians, he could have and should have said so explicitly. That was the common law rule, and he's charged with knowledge of it. In this case, this is totally, he got $22,000. They got $50 a day for 444 days.
Counsel, why do you say that? Why do you say it was the common law rule that if you were unexplicit, property could, posthumously acquired property could pass? I mean, there are some cases that say that. You say in dicta that are more modern. But if we really are bound by what the consensus common law rule was back in the 1800s or thereabouts, what is the common law support for the kind of narrow exception that you acknowledge, which is if a will is clear enough, it actually can pass posthumously acquired property? Where would you point us to the kind of cases that you seem to think would be binding on us? How far back can you trace the idea of some sort of an exception rather than just a categorical formalistic rule didn't exist or you didn't own it in the relevant sense at the time of your death, can't pass by will?
The classic rule, Judge McLeese, is that there is no testamentary capacity whatsoever. In dicta, the courts in the few cases that have considered it have said, if there is clear, unequivocal intent, maybe we would apply the will if the testator said, I have a future potential claim and I want my future assets to go to such and such person. However,
right,
none of the
my
cases
concern
have found
is that there are two of your lines of thinking are running up against each other in a way that I'm not sure how to reconcile. One of them is we are bound by the common law as it existed a long time ago, the consensus common law of a long time ago. That's one line of thinking. That seems, by your answer right now, to suggest we're bound not to acknowledge any exception, no matter how clear the will would be. But the other line of thought is you have acknowledged in questions that it is permissible for this court to acknowledge an exception if the will is clear enough. And I'm not sure how to reconcile that acknowledgement with your broader theoretical position about what's binding on us. So can you help me figure out how to reconcile those two things?
Well, Judge McLeese, I don't think you need to reach the issue, just as the other courts in the Marilyn Monroe case, the Brahmans case, did not reach that issue, because on these facts, the Victims Act compensation was completely unforeseeable and was actually, as I said, the second set of compensation awarded by Congress. The hostages got $50 a day in 1986, a year after William died. This came from fines as a result of the BNP Paribas French bank. So I don't think you need to reach the issue. Which rule? Well, that's why you are appointed as judges, because you can decide that. Because in order to ameliorate the...
I'm sorry, you mentioned that we can decide this issue. And we've been talking about your references to the general common law. You mentioned a couple of different cases. You mentioned what we refer to as the Marilyn Monroe estate case, the Shaw family case. Hasn't that case been overruled? And if not, what impact do more recent cases like the Crosby versus HLC case or the Shaw Family Archives case have on this Marilyn Monroe case?
Judge Blackburn-Rigsby, it has not been overruled as to its key holding that Marilyn Monroe's right of publicity passed by intestacy and not under her will. That aspect has not been overruled. What did happen was, and the Ninth Circuit has approved of that aspect of the intestacy aspect of the Shaw case, the Marilyn Monroe case. I believe what you're referring to is that the California legislature passed a special law by statute making retroactive certain naming or publicity rights to Marilyn Monroe and others similarly situated, even though they didn't exist at the time of death. But that doesn't change the principal holding of the Shaw case. That has not been overruled nor even questioned by any court.
And even though
The-
that is not binding on us here in
Right.
DC, you still refer to that as part of the general common law that we still have to follow in some way.
It is applying a common law rule that on these facts makes a lot of sense. And as I've stated, if you apply the will as the appellant wants, you're going to have a result that we think was inconsistent with anything William would have wanted, which is everything goes to Catherine's estate in New York. I emphasize, Catherine, it was a second marriage, but a loving relationship. She died of bone cancer in her early 60s at a young age, and she left a will. That will was written, it's in the record, in July of 2004. And the will left everything, the residuary beneficiary is Stephen. But Catherine could have remarried. She survived her husband by almost 20 years. Catherine was the president of St. John's Fisher University in Rochester, New York. She could have left her money to Rochester, to the university in Rochester. Stephen's rather pious exhortations that he wants to carry out his father's intent are colored by the fact that he happens to be the residuary beneficiary. Would Stephen take the same position if Catherine had remarried and left it to her second husband or third husband, I believe, or to her university? And that's the whole point. The common law rule on these facts makes total sense, because if you apply intestacy, you would have 1/3 applying the law in 1985 goes to Catherine and therefore her estate, and the rest is split among William's children. Intestacy carries out on these facts the intent far more than applying the will, because applying the will means that Catherine, in her will, is in effect disposing of these monies. And is that what William really would have wanted? And it's an example of where the common law rule makes a lot of sense. In fact, in New York, the joke may be on Stephen, because if intestacy applies in New York, Catherine's brother is going to end up with it all. And that's a result that I think we can agree William would not have wanted under any set of facts.
Why do you think that
Right.
again? If you think that what William wanted, what the husband wanted was let his wife decide what to do with all of his remaining property, then maybe that is what he wanted. He wanted her to have it and her to do with it as she saw fit in her life or after. So maybe it is what he wanted. It's again, we don't know for sure. And I understand that is relevant to whether you think of the inquiry here as speculative or how do you figure out his intent. But in any event, I don't think it's obvious that that's not what he wanted. He may have, again, he gave it all to her. With respect to property that existed at the time of his death, he gave it all to her to do with as she saw fit. That's what he decided to do.
Well, again, Judge McLeish, I think we go back to the common law and to a core argument. You cannot separate intent from the assets that exist at the time of death. It's one thing for William to say, he didn't even have enough assets to open his will when he died. I mean, he was dying of AIDS. He couldn't work. He was a very sick man. So he didn't have much. What he wanted was for his daughters to graduate from college and whatever was left to go to his wife. You don't know what his intent would be 30 years later on a 4.4 million. That's a potential, because it depends on money coming in under the Victims Act from fines collected from violators of the law. It doesn't come from general revenues. But how you dispose of 4.4 million that unexpectedly arises 30 years later is a very different question from what William wanted in 1984, 1985, the few $1,000s he had to his name, where that would go. I believe that shows the wisdom of the common law. And this case is a good illustration that the common law position makes a lot of sense, which is why most states have not adopted the Uniform Probate Code. And the Uniform Probate Code says at most, and it's recommended version that a will may provide for disposition of assets that are acquired after death. It doesn't mandate that. The New Jersey version, which I quoted in my brief, says that a will be deemed to provide for postmortem assets unless it says otherwise. Again, that emphasizes the legislative and the policy nature of the decision, and why what William is asking you to, what the appellant is asking you to do is legislate and and alter the common law, which he derides as antiquated, and in order to favor him over his sisters. And we respectfully submit that the common law makes sense.
All right,
That-
Mr. Rescio, I know we've taken you over your time with our many questions, and we appreciate your responses. Did you have any brief final remarks before we turn to appellant for their brief rebuttal?
Thank you, Judge Blackburn-Risby. Simply that the common law rule is a sensible rule. It is clear what it is, and it should be applied by the court. Whether you apply the strict rule that there is no testamentary capacity whatsoever, or if you do what the trial court did, which is say, you know, if there was unequivocal language of intent to dispose of future assets, maybe we could apply it, but we don't have that on these facts. You apply either one of those two rules, as the court should, and the result will be affirmance of the judgment below, which I would urge that this court do.
Great, thank you. Mr. Johnson, I think you reserved 3 minutes for rebuttal. You're on mute, Mr. Johnson.
Sorry, thank you. The residuary clause of the will says, I give all the rest of my property, all the rest of my property. Judge McLeese, you asked the question, what's equivocal about all? And there was no answer to that question because it can't be answered. There's nothing equivocal about it. He very clearly left all the rest of his property to his wife, Catherine. The rule that you're being asked to recognize or adopt is some sort of a vague notion of what applied in Great Britain. And there are cases in other jurisdictions that in various forms have recognized this, but I think the questions all have demonstrated how unworkable this is and how there's no rationale for it. It's a formalistic, arbitrary determination that says you're not allowed to dispose of anything if it is acquired after your death. And that rule has never been recognized in the District of Columbia. It's never been recognized in Maryland. And the exceptions would swallow the rule. Well, maybe if you're clear enough in what you say, then you could dispose of property acquired after death. You couldn't be much more clear than to say all the rest of my property.
Well,
And that's
except
what-
Mr. Johnson, but that still runs into the problem of DC Code Section 18-303, which defines the term all of my property or all of the rest of my property to mean the property over which you have a general power of appointment at the time you're saying that. I mean, how can that be interpreted to include something that comes 30 years later that I think most people would agree you don't know is coming, and you certainly have no claim over it.
Well, we think he knew it was coming, and he has a power of appointment in the sense that he has a personal representative who will be appointed to take control of the estate, to marshal the assets of the estate, whatever they are at the time when they come into being. There's never been in our law any limitation anywhere that says a testator has some arbitrary restriction on him or her that they can't provide for something. We've never said that. And I don't even think 18-305 can be read to say that, because 18-305 is specific to real property. And if you take that argument literally, that means you can't dispose of personal property acquired after the execution of the will. That's not the law in the District of Columbia. The law in the District of Columbia is that the intent of the testator is the pole star. That's what we follow. That's what we try to apply. And that's been the law for hundreds of years, that if there's any way to avoid an intestate distribution, we avoid it. And yet the result that the trial court forced and that the appellee asked you to affirm is one that would disregard the last will and testament, disregard the testamentary intent, and force an intestate distribution, which we've never done. And to try to figure out exactly what the law is and where it comes from, I think is an impossible exercise if you go down the path that the appellee is suggesting, and that you follow what the trial court did in this case. And I think one of the things that the trial court did that's of note to try to get to the result that was reached is to, for one thing, to take United States versus Baker and say, well, that case doesn't apply because there was a real estate asset and it was exchanged for money. And even though that happened after death, it doesn't matter because they were basically fungible. I mean, that's a fiction that's created to get to that result that says you can't dispose of property if you didn't own it at the time of death. And if this court affirms that fiction, I don't know how you would ever figure out what the law is in the District of Columbia on this issue, because how could you be specific enough to say, and there certainly are times people walk around all the time saying, I'm going to inherit this property or I'm going to inherit this money, and they think they are. And maybe they're right, maybe they're wrong, but are they not allowed to make a disposition in their will that takes that into account? Are they not allowed to make a disposition in their will that's a catch-all that says anything else that is within my property I want to dispose of in a certain way? I think they are. I think that.
But Mr. Johnson, I just want to make sure I understand exactly what your position is. Am I correct that your argument is that where Judge Pittman made an error was in determining what the common law rule is? Is that correct?
That's one of the errors. He also made an error in saying that that is a rule that binds the District of Columbia somehow, because.
Well, that's what I mean. That's what I mean. That the common law of the District of Columbia. Your position is that he misread what the common law, or misstated what the common law of the District of Columbia is. Is that correct?
That's one of the things he did. In part, part was relying on something in Maryland that he said was common law, which is not something that the courts in Maryland have said. And then the Shaw Family Archives case that he put a whole lot of emphasis on in reaching the decision, he ignored Marcus versus Dufour, which was decided after that. I mean, Shaw Family Archives isn't even the law in New York, as indicated by the fact that in the Catherine Keogh estate, you've got two rulings from the Surrogates Court in New York that address it specifically and say that is not a rule that binds us. The statute doesn't.
But if we were to conclude, I know you disagree with this, but if we were to conclude that the common law rule in the District of Columbia is as Judge Pittman said it is, and if we were to conclude that no DC Code statute or other applicable statute changes the common law on the point at issue in this case, that we would affirm the decision. I mean, that has to be correct, isn't it?
If this court finds that the common law in the district is as Judge Pittman found it, that would be.
And that no applicable statute holds otherwise.
Then I think that's the result, but that's the wrong result, with due respect, Judge Kravitz. And in part, I think you have to look at the overall scheme of estate planning and the probate cases in the district. The district also recognizes a residuary clause and gives that power and effect. And that's been the case for many, many years. And we want to uphold that intent if possible and give a testator the right to set up sort of a catch-all that says anything else that I have in my residuary estate, here's how I want to dispose of it. We recognize and effectuate that. And what this is saying is, essentially, we've never actually recognized it because there's a very significant limitation on it, which says if it's property that comes into your estate after you die, you're not allowed to dispose of it. And that's never been the rule. That's completely inconsistent with all the cases that have recognized intent. I mean, I think it's even notable that in the estate of Ford case that came out in 2019, actually in January, after we had our hearing in front of Judge Pittman, when this court recognized equitable adoption, and I know Judge Blackburn-Rigsby was on the panel that decided that case, they looked at the different rationales for recognizing that doctrine and chose the one that said it focused on the decedent's intent. That's always been the poll star in the District of Columbia, and to ignore it here in deference to some sort of rule that may have existed in Great Britain, that's reversible error, and that's what this court should not affirm and should reverse and should direct that the will be followed. I'm certainly willing to answer any other questions. I appreciate the time before you, and we would ask that the order appealed from be reversed.
All right, thank you. We'd like to thank both counsel for your briefs and arguments in this case today. And we will be taking the matter under advisement. And counsel, you're free to exit our virtual courtroom at this time, and we'll prepare for our second case. All right, good morning, counsel. I see counsel for appellant still connecting, so we'll give Mr. Colbert, I'm sorry, counsel for appellee is still connecting his audio, and so we'll wait just a moment.
Good morning. I think I'm here now.
All right. Good morning, counsel. This is our second case this morning. This is the matter of Gray versus U.S. Are parties ready to proceed at this time?
Appellant is ready, Your Honor.
All right. Thank you. Mr. Winograd, is that correct?
Winograd, yes, Your Honor.
You can proceed.
Thank you, Your Honor. May it please the court, I'd like to reserve 3 minutes of my time for rebuttal, if I may.
Okay.
Thank you. I'd like to begin the case on the point of error that I raised, which is the trial court improperly allowing cross-examination regarding an internal affairs complaint that Mr. Gray had made. That's the first issue I'd like to address. There are two ways, I believe, that this can be looked at. One is the government's theory that both in this court and in the trial court, that this was somehow some sort of plan to allow Mr. Gray to undermine the government's case, and therefore was relevant to the cross-examination. The other way to look at it is what the trial court used the term bias. And while bias is relevant as a general matter, in this particular case, the foundation for bias, that there would be bias and that the extrinsic evidence with which a party wishes to cross-examine has to be relevant to bias. And the government did not make either of those showings in this particular case.
Can I ask about you used the phrase extrinsic evidence. that often means that there wasn't only cross-examination questioning, but then someone went on and introduced some evidence other than just the questions and whatever answers they elicited. You're not suggesting that that happened here. So I was a little confused by your use of the phrase extrinsic evidence. I mean, the cross-examination referred to events that hadn't yet been, weren't otherwise in evidence, I guess. But was there extrinsic evidence then later introduced?
Eventually, yes, Your Honor, because in order to rebut the government's attempted here, Mr. Johnson, Mr. Gray's trial counsel, was forced to bring out the fact, to bring information in front of the court, such that explained what had happened. Mr. Gray never, nor his counsel, neither in the government's case in chief, nor in cross-examining the government's case in chief, nor in Mr. Gray's presentation, ever raised the issue. That the government was the party that decided to bring this out, which is why what I was explaining was that the government cannot, on one hand, say that this is some great plan to undermine the detectives' credibility and besmirch the government's case, which is what they relied upon both at the trial court and in this court, the theory that why this was relevant, and then say, well, and then to bring that out, but it would never have been in front of the trial court but for the government eliciting it. So it's not possible.
Well,
Yes.
I mean, I get your point that it may be pretty speculative and maybe giving Mr. Gray a lot of, credit for his legal sophistication if this was all part of a clever plan to introduce some impeaching evidence at trial. But I don't know that the fact that the defense chose not to introduce that evidence at trial, if it was otherwise a logical inference, would be relevant. I mean, okay, imagine that there was evidence that Mr. Gray, who was a lawyer, had said, what I'm going to do, I'm going to go and I'm going to get some false charges. I'm going to bring some false charges against the detective, and then my lawyers can be able to use them to destroy the credibility of the detective at trial. Imagine the government had proof of all of that. And then at the trial, the defense decided, well, I'm not going to try to impeach the detective with any of that. That's not going to get me anywhere. That wouldn't undermine the relevance of the cross-examination. So I don't quite understand why what evidence the defense introduced at trial is very germane to the inquiry. I do get your broader point, I think, which is, like, how plausible is it that Mr. Gray is, kind of a legal mastermind thinking, oh, step one, false IED reports, step two, then at trial, my lawyer will impeach the detective. I get that line of thought, but I'm not sure I follow the rest of the point you were making.
Well, to the beginning of your point, Your Honor, that was actually the next point in my outline, which is that Mr. Gray is not a sophisticated party. So the theory that he planned this is completely implausible. And planning it is something that the government relied on to make it relevant. So there was not only was there no evidence of that plan available because it didn't exist, but the fact that it possibly could have been a plan is also so far-fetched as to make the theory underpinning the relevance of the cross-examination. Let me back up. As to make the cross-examination irrelevant. I would also note, Your Honor, that the problem here, to get to your question, Judge McLeese, the problem being that let's say that he chose not to introduce it, it would be relevant because it existed, and therefore the government could go and attack it. So he might have done something to try and undermine, in your hypothetical, Judge McLeese, let's say Mr. Gray did something to, in fact, try and undermine the government's case prior to trial. That's what his plan was. We'll assume that for this hypothetical. He does that, and then the lawyer chooses not to introduce it. The fact that he did it in the first place for that reason would, in fact, be evidence that he was intending to undermine the government's case. And because he did it, even though he didn't introduce it, the cross-examination would be relevant. But the first prong isn't present here.
Yeah, but Mr. Winograd, I mean, to me, it just seems like a classic corruption bias theory of cross-examination. And while you're probably correct that for this to be allowed to go to any meaningful extent in the trial, the cross-examiner would have to make a pretty good proffer that these were bogus or false complaints filed with a corrupt purpose. But this is exactly the kind of cross-examination that defense lawyers are arguing all the time, that they should be allowed at least to begin on in an exploratory way, and that they don't have to necessarily be bound by someone saying, oh, this witness is not sophisticated, and so it's implausible that he could have been acting with this corrupt intent. We have a right, the lawyers will always say, we have a right to explore it ourselves, and maybe cut us off after a while, but don't cut it off completely. And I mean, it just seems to me that that's what was happening here.
But for a corruption bias to be present, Mr. Gray would have had to have a reason to fake this IAD complaint.
I don't see why that's true.
And that's what cross-examination is about.
Yeah.
But that's not what occurred at the trial court.
But in any event, I don't think it's true. If one way of looking at corruption bias is Mr. Gray is going to testify at trial, there's a question about whether he should be believed or not. Here's a thing you might want to know, Judge. He has filed false police reports. He's gone to a police officer and said, an officer, it even has connection to this case, but assuming it didn't, it's like he goes and lies about what police officers are doing and makes reports to try to get them in trouble. So he doesn't seem, he's not the most credible guy. He was, that's a different line of impeachment that doesn't really turn on what his reasons were. Maybe he hated the officer, but he was for whatever reasons, he was willing to do this. And so, not the most believable person. That's, I think, maybe what the more general bias language is about. That I don't think the word corruption bias was necessarily used. The corruption was used in the trial court. I don't remember, but I think that's one way of looking at what. Again, I agree with you. The United States made a more specific argument about trying to damage the officer. That was one of the points for sure. But what's wrong with a more general idea that, someone who's trying to decide whether to believe your client should be aware, as things would have it related to this case, that he, went in and made false reports about illegal conduct by police officers?
Because to cross-examine him on something because first of all, the reports were not false. So that's number one. And I understand that the trial court is supposed to make that determination, but the trial court never did in this particular case. Mr. Gray's lawyer, once he was put in the position where the government had been allowed to cross-examine, had to, on redirect, then bring in evidence to show that Mr. Gray was not, in fact, making a false report. What had happened was the officer had checked on the car had come back that supposedly Mr. Gray had stolen the car. Mr. Johnson introduced evidence that the Maryland DMV believed that, in fact, that there was a stolen car, that the affidavit in support of the arrest warrant said that Mr. Gray was a drug user and a violent individual. And those are the reasons that he went forward and made the IAD complaint. There was no connection between the IAD complaint and this case. I would also note, Your Honor, that while there might be that one of the reasons that the proffered reason by the government at trial was that Mr. Gray was attempting to undermine the government's case. Not that there was some other general bias that Judge McLeese that you just referred to, that when the purpose of this was to undermine the government's case. And there's nothing.
I'm sorry, I didn't mean to stop you midpoint. I hear your arguments about the cross-examination and bias issue, and you sort of just morphed slightly over to one of your other arguments about hearsay with respect to the affidavit. And I wonder if you could touch on that a bit before your time runs out.
Absolutely, Your Honor. I'll touch on that right now. I would note this is the basic basis is this, and this happens in Superior Court, in that the motions hearing was heard during the trial. That in and of itself is not improper, but it never was, and I apologize for the colloquialism, cleaned up. So basically what happens here is that the evidence of how long the car was impounded for, in this case, we know from the record, 3 months, whether or not it was watched over during that time, and those issues, those things came in for the truth in the case in chief. The court itself recognized that for the purposes of the motion, they could hear the hearsay that comes in the affidavit. But the court itself also recognized, if you go to starting at page 60 of the April 17th transcript, that the facts themselves, the time, place, and manner that would make this evidence that was taken from the car relevant were actually were not. There was a hearsay exception would be required for them, and the parties at the trial and the trial court never come back and fix that issue. The trial judge says, well, I can admit this because it's sworn to and it's evidence, and therefore I can admit it. And she admits the affidavit in support of the search warrant.
I'm sorry, you think it was
affidavit
admitted for you think it was admitted for purposes of guilt or innocence?
I do.
And what in the transcript leads you to think that?
Because at the beginning of the colloquy, of the beginning of what was the internal motions hearing, at page 60, both the government and the trial court recognize that the facts about the time and the distance between when the evidence was first impounded and when it was collected, and whether or not that makes it relevant to Mr. Gray's actions at the time, whether or not that evidence was collected, the court and the government recognized that in fact had to, that they would need a hearsay basis for that. And no one ever goes back and says, okay, I'm going to examine the probative nature of whether or not those things were seized close enough in time. It never gets.
Right, but the government's argument, I think, is that just what you said is right as far as it goes. An issue arose about hearsay. People realized that if it was going to come in for truth or for guilt or innocence, there would need to be a hearsay exception. Then there's discussion about, but we also have a suppression hearing going on in the middle of all this, and hearsay is admissible for that. So then let's hear some things for purposes of hearsay. And then if nobody goes back and finds a hearsay exception, then isn't the natural inference that it was never admitted and nobody thought it was admitted? I mean, well, leave aside what people thought, that it wasn't admitted, that the trial court didn't believe it to be admitted and wasn't admitting it for purposes of guilt or innocence because the trial court flagged a problem that was an impediment to admissibility and nobody ever asked that it be fixed.
Respectfully, Judge McLeese, no, because at page 81 of the transcript, Mr. Johnson objects again. He raises the same objections he had raised before. He says, I'm raising the same objections before, and the trial judge just passes over with it. And so the point of the objection was, it was originally a motion in limine. It was not a motion to suppress. It was a motion in limine saying that the evidence was too far removed.
I'm sorry, page 81. Can you
Yes.
help get oriented here?
They're bringing in the evidence of the car at this point. I believe it's page 81.
So this is the tangible evidence comes in.
Correct. And the point of the motion in limine was to exclude that. And the reason it was to exclude that was because it was too far afield. And then Judge Broderick says, no, I'll have to weigh whether or not the probative value and the relevance based on the time frame at trial. But the evidence underlying those things, the probative nature of the evidence, the relevance, where it was, how it got there, was it's admitted. The detective is saying, this can't. I know this. How long it's been in Mr. Gray's car. I know that it's been that somebody's been watching this car the entire time. I know no one could have tampered with it.
Can you see if I get your argument? Is your argument that although the search warrant affidavit itself was never admitted for the truth explicitly, for guilt or innocence truth, when the judge later admitted the tangible items that were taken from the car, those were properly admissible as relevant only if one gave truth, treated as true the information in the search warrant about what had happened to the car in the interval. And although nobody made that explicit, what that means is that implicitly the trial court must have been treating the information in the search warrant about the circumstances of the car in the interval as having been admitted for the truth and as underlying the admission of the evidence of the tangible evidence that was taken from the car. Is that your line of
Yes,
thinking? Or
that sums it up very well. That's correct.
Can I ask a question about that? Because I think the point of the point of the evidence in the search warrant affidavit was to show that the fact that these items were still in his car 3 months after his arrest were relevant in that they indicated that they were likely in his car at the time, at or near very near the time of his of this incident, right? Because the evidence was that the car got impounded 3 days after the incident and then remained impounded with no one having access to it until it was searched. But so this is my question. Let presume for the purposes of this question that the trial judge made a mistake in allowing this to come in either explicitly or implicitly to show that what was found in the car was of some significance. On cross-examination of Detective Koselowitz, and specifically on pages 6 and 7 of the April 22nd transcript, the defense brought out the exact same facts to try to show the significance of the fact that there was no gun found in the car when it was searched 3 months later, because that's in fact what happened. The car is searched pursuant to a search warrant 3 months later. They find these other things like ammunition and a gun box, but there's no gun. And the defense is trying to show that fact, the absence of a gun, is highly significant. And the way that the defense counsel makes that point is by bringing out through the detective precisely the same information that you say Judge Broderick improperly considered from the search warrant, specifically that the car was impounded 3 days after this incident and was then in an impound lot, no one having access to it until it was searched. So it just seems to me, given that the defense brought this out itself, any error here has to be harmless.
2 points to your question, Judge Kravitz. The first is that the only reason, to go back to the beginning of your question, the only reason we know that the car is being watched and these items come from Mr. Gray's car and that we're sure that they are circumstantial evidence of him having a gun is because of impermissible hearsay. I mean, all the fact that it was impounded and where it was is all second and third hand to the detective. As to the cross-examination, what other choice does Mr. Gray's counsel have? This didn't come out after that evidence comes in. If I'm the trial lawyer, and I do that a lot, I simply can cross-examine on the fact that there is no gun. I don't have to bring out the fact that this car has been held and no one's touched it and it's been secured, unless the government is allowed to put in this
But you might well want to. I mean, I was never a defense attorney, but you might well want to, because it certainly makes your argument stronger if the idea is, well, here's, my client is alleged to have had a gun on date X. And by the way, here's really good evidence of his innocence. 3 months later, there was no gun in the car. I mean, that's a fair enough point, I guess, but it's not the best point as a defense lawyer. Whereas I would think it'd be a much better point to say, still not unassailable, but it's a better point to say, my client is alleged to have had a gun in the car on date X. The car got, seized, I forget, a couple days later, and then no one had real access to it, very limited access to it. And then when it was ultimately searched, no gun, but that really shows you that there was pretty strong reason to believe there was no gun when he was stopped in it a couple days after the incident. That's a much better line of reasoning as a defense lawyer, I would think.
Perhaps, But what an even better line of reasoning is, there was never no one ever found a gun on Mr. Gray. And in addition to which, none of the evidence that has been admitted that would be circumstantial evidence of this gun, the gun box and the ammunition, was ever found. It wouldn't have been admitted.
Mr. Winograd, I think you sort of morphed over slightly into one of your final areas of argument on appeal, which is your general challenge to the sufficiency of the evidence. And I just want to, it's not clear to me whether you're challenging the sufficiency for each of the counts, possession of the prohibited weapon, the assault, or the unregistered firearm. Could you clarify what the deficiency or the lack of sufficiency of the evidence is? Is it based solely on your argument that no gun was recovered?
Yes, Your Honor.
And we have other cases that you can point us to where the simple absence of the weapon is in and of itself causes the conviction to fail?
No, Your Honor. I don't have a case that in this particular set of circumstances that the absence of the gun itself would vitiate all of those issues. But I raise the point because, as Mr. Gray has made clear many times, that there was no gun found on him, and I
know the trial court, we have the trial court's findings of credibility of Ms. Jasper's testimony of the gun. And we also have, if I'm not mistaken, Mr. Gray's admission that he did in fact own a gun, which he kept in the car in the lockbox. And I think there was ammunition recovered in the car, albeit sometime after the offense. Why wouldn't that evidence, viewed in the light most favorable to the government, which is what we were asked to do on appeal, survive a sufficiency challenge?
Your Honor, my position is simply that that without the gun, the credibility determination was a mistake, and that's why it should not survive a sufficiency challenge. And I'll rest on that.
Okay. All right. Well, thank you, Mr. Winograd. We took you over your time a bit with our questions, but you reserved your time for a rebuttal, which we will honor after we hear from the government counsel here.
Thank you, Madam Chief Judge, and good morning. Matthew Covert on behalf of the United States. The judgment of the Superior Court should be affirmed for 4 reasons. First, the United States was the proper prosecutor for these offenses.
Can I interrupt you briefly, Mr. Covert?
Sure, of course.
Covert or Covert?
Covert.
Covert, Mr. Covert. Do we have cases in DC where we've upheld possession of a prohibited weapon gun and an unregistered firearm case where the firearm and gun were never recovered?
I can't think of a case specifically. I did take a look at that point.
I have to say I'm a little troubled by that. I'm a little troubled by that. I know we have the credibility findings of the trial judge here, which were pretty unequivocal, but I did try to see if I could find any cases where we had a possession of a prohibited weapon gun, unregistered firearm gun, and no gun. Can you talk to me about why we still have enough evidence here, and why, were there cases from other jurisdictions that you found where they upheld a conviction like this without the gun? I guess I have some sympathy for that point, that why don't we have a gun here for these gun charges? Why should those charges still stand? I see the threat perhaps could stand, but why should those 2 very specific gun-related charges stand here without any gun?
Sure. So I think it ties all the way back to what Your Honor pointed out at the beginning of your question, which is the trial court's credibility findings about Ms. Jasper's testimony. So if we proceed with the assumption that there's really no legitimate challenge, at least to the sufficiency of evidence as it relates to the assault and the threat, this is all one continuous and operative act. And so if we all agree, perhaps not Mr. Gray, but if we all agree that The assault here was Mr. Gray pulling out a gun from the glove box of his car and obviously holding it in his hand and pointing it at Ms. Jasper. There is sufficient evidence that on December 12th of 2017, Mr. Gray had a handgun in his possession. So that evidence, coupled with the stipulation as to Mr. Gray's lack of firearm registration in the District of Columbia, certainly it creates not only sufficient evidence, but compelling evidence, given the trial court's credibility findings, that he had a handgun, an unregistered handgun, in his possession on December 12th, 2017. The absence of the gun, the fact that a gun wasn't recovered from the vehicle, it certainly goes to the weight of the government's evidence. It's certainly ripe for cross-examination, as defense counsel did in this case, as Judge Kravitz pointed out. But in terms of sufficiency, the evidence is more than sufficient to show that on December 12th, he had a gun on him, given the trial credibility.
Do those statutes prohibit the possession of imitation firearms without a registration, or only real firearms?
I believe real firearms, Your Honor.
So how do we know that this was a real firearm?
So Ms. Jasper testified that she herself also owned a firearm, and she testified that based on what she saw that what Mr. Gray was pointing at her, that she perceived that gun based on her experience to be a legitimate weapon. And I think second to that point is that Mr. Gray admitted that he owns a real firearm, and that on occasion he would travel with that gun in his car. So I think the idea that the remote possibility that this might have been an imitation gun, one, wasn't raised by defense counsel at all. That was never a theory that he raised, either on cross or in closing argument.
But there was a motion for judgment of acquittal, no?
There was, yes.
And I thought the complainant said that all she saw of the gun was the hole at the end of the barrel.
I think, yeah, that's true. She testified that she sort of saw the front of the gun and she was able to identify it as black.
Right, so-
Doesn't the gun also have to be operable to under a PPW charge or unregistered firearm charge?
That's correct, Your Honor.
How do we know that here?
I think it all flows from the inference, I suppose, that
There wasn't any specific testimony or that I could recall specific finding by the trial judge. I may have overlooked that in the trial judge's order. There was no specific finding by the trial judge that the gun was operable, or that she inferred that the gun was operable based on whatever testimony.
She talked only about credibility.
I think that's correct, Your Honor. In terms of operability, I think the record is silent as to the trial court's findings on that point. I suppose if we were to look at the totality of the record and the evidence that was presented to the trial court, we would then probably look at the evidence that was found in the car. And I think, if I recall correctly, the government, in its direct examination of the detective, asked the detective, as for the gun magazine and the ammunition that was found in the car, is this a real gun magazine? Is this real ammunition? And the detective said yes. And so, while not squarely on point as to the gun, certainly probative on that point.
Now, would the assault charge and the threats charges stand even if there were no gun here?
Can you maybe clarify your question? When you say there's no, if there's no gun.
Without the gun, do we still have a sufficient basis for finding an assault and threat here?
I just want to make sure I understand. When you say without the gun, do you mean if the gun had not been a part of the alleged facts, or whether the government just didn't have evidence that a firearm was used at all? I just want to make sure I understand the nature of the question.
If the PPW and the unregistered firearm counts fail here, would there still be a sufficient basis for conviction on the assault and the threat charges?
Oh, absolutely, because then we're still talking about intent to frighten assault, and I suppose backing up a step and saying, well, whether or not this real or remote possibility imitation handgun was used, it was clearly used in a way to threaten and frighten Ms. Jasper, and she, as she testified very clearly, she certainly perceived it that way. So that there's certainly no requirement for assault or for the attempted threats count that the gun had to be real, so long as it was used in a way to frighten her. And if there are no further questions on the sufficiency issue, I'll turn to the first issue that my friend Mr. Winograd raised, which is the scope of cross-examination as it relates to Mr. Gray. The trial court did not abuse its discretion in permitting the government to question Mr. Gray about his attempt to file a complaint against the detective for a very straightforward reason. This evidence was relevant to impeach Mr. Gray's credibility as a testifying witness, and was evidence, albeit maybe not the most persuasive evidence in the world, as Judge McLeese pointed out, but nonetheless probative of an effort to affect the credibility of the government's lead witness. I think one issue that didn't come up in Mr. Winograd's argument, and I want to make sure I mention it to the court, is we're not just talking about the falsity or the alleged falsity of these allegations in terms of its probative value. There was one other issue that the government mentioned to sort of tie up why the circumstances surrounding these efforts were probative, and it was timing. So Mr. Gray was released on his personal recognizance after a preliminary hearing in January of 2018. I think it was January 10th. He doesn't make the complaint at that point. The arrest warrant had already been issued in December. 13 months pass where Mr. Gray makes no effort. He has no administrative grievance. He makes no issue of the fact that these allegedly false statements were made in this arrest affidavit, or that there was a false stolen vehicle report filed. It's only 13 months later, less than a month before his trial, that he makes these complaints. So it's the timing of the complaints, as well as the theory that these charges were essentially bogus, that gave this evidence pretty obvious probative value, particularly in light of how broad cross-examination can be of any witness, and in particular, criminal defendants when they take the stand. And I think in terms of error, I just think there's no legitimate argument that I can conceive of that says that this was outside the bounds of the broad scope of cross-examination that the government can do when they are cross-examining a criminal defendant. And I think, Judge Kravitz, you pointed out sort of the very limited way the government used this evidence, both I think affects the error analysis, and even if there were error, any harm. I think it's actually Judge McLeese, you mentioned the sort of extrinsic versus intrinsic evidence distinction. All the government was doing was using intrinsic evidence on cross-examination of Mr. Gray to poke and prod and to make an attempt to see what he would admit to as far as his efforts to make these complaints. Now, it's true that in its rebuttal case, the government did have to make an attempt to call Detective Haselwitz to establish the falsity of his statements in the arrest warrant affidavit, specifically those 3 boxes that he checked, that Mr. Gray had violent tendencies, was known to use drugs, and was armed and dangerous. Now, interestingly, at that point, when the government attempted to establish the falsity of those, or the lack of falsity, I should say, the truth of those statements, with the detective, defense counsel objected. He objected and he said, well, we can't get into that. That's too far afield. So the government made every effort to comply with the court's ruling, cross-examine Mr. Gray with intrinsic evidence, and at the court's behest, attempt to introduce extrinsic evidence, but ultimately was shut down by defense counsel. So in terms of error and harmlessness here, I just think appellant's argument doesn't go very far. And I suppose there's one additional argument as it relates to harmlessness, and that's the fact that the trial court never referenced this testimony in its findings. The government made a very brief point of it in its closing, and as we point out in our brief, the strength of the government's case was Ms. Jasper's testimony and the weighing of credibility that the trial court made in assessing her testimony when compared against Mr. Gray's testimony.
Can I
And
ask
so-
you about the hearsay, about the hearsay issue, which you haven't
Of course.
addressed yet? And I just want to make sure I understand the government's view about what came in for the truth about the circumstances of the car in terms of when it was seized and what happened to it until the point when it was searched. What actually do you think came into evidence at trial about that for the truth? For
So
Gilbert?
Sure. So the evidence that came in for the truth, as I read the same trial transcript pages that Mr. Winograd is referencing, is that on March 8th, the detective learned that that Alexandria City Police Department had the car. And on March 14th, he executed the search warrant. And at some unknown date, the record doesn't clearly establish it, but at some unknown date in between, he oversees the transfer of the car from Alexandria to Department of Forensic Services in DC. That's the extent of the evidence that comes in for the truth. Everything else.
The problem with that analysis, I mean, I've read the transcript, that part of the transcript now several times, and I think it's ambiguous as to what the judge was saying that the search warrant affidavit could come in for. I just think, I don't know that we'll ever be able to parse it with confidence. But the problem with the government's understanding, in my view, is that if the substance of the search warrant affidavit did not come in, either explicitly or, as Judge McLeese suggested earlier, at least implicitly, then the evidence of what was seized from the car would have no meaning in the trial. The judge wouldn't know how much weight, if any, to give it without the information about what had been happening with the car in the intervening 3+ months.
So I think I disagree with the premise of the question that the evidence from the car would have no probative value. Certainly the weight of the probative value would have been diminished in the absence of the other evidence that the government was able to introduce. But bottom line, we're still talking about a search of the defendant's car 3 months.
So fair enough. I probably spoke a little bit too much there, but the judge wouldn't know how much weight to give it.
I think that's probably true, and I think that this sort of leads into a point I wanted to make about the search warrant, was that sort of putting it in context for how the issue was teed up for the court. It was a motion in limine under Rule 403, not 401. So I think the party sort of understood that, look, this evidence has obvious some probative value. What we're debating is how much weight to give it. And so under Rule 104, when you're talking about the admissibility of evidence, the trial court, it's obviously different in a bench trial when you've got a fact finder and the gatekeeper serving the same function. But the court was sort of looking at this and saying, okay, in assessing the weight of the probative value as the gatekeeper of the evidence, I'm going to consider, this hearsay. But as a fact finder, I'm going to contain myself to what's before the fact finder. And I think the record is.
I get the idea that can be done in theory. I think it's pretty opaque from the trial transcript whether that's what the trial court actually was doing. And I guess part of the reason I asked you about your understanding of what evidence actually came in about kind of the circumstances of the car and the recovery of the object seized is because I wanted to direct you to the prosecutor's closing argument. It's on page 86 of, I'm not sure what day that is, whether it's 17th or the 22nd. It's on page 86. And the prosecutor is addressing, I mean, this might be rebuttal closing. The prosecutor is addressing the argument, no evidence of a gun. And the prosecutor says, the evidence is all of that physical evidence that was in the defendant's car just days later, magazine, bullets, 2 gun boxes. That seemed to suggest that the prosecutor understood that evidence that the car was seized a couple days after the incident, three or 4 days, I think, and then was kind of in custody thereafter, had come in for the truth. Unless, I mean, I guess everything is just days. I mean, years are just days if you add up enough of them. But it's a funny way of expressing the thought if what the prosecutor was trying to say was, well, here's what we know. We have no idea what happened to the car for several months, but when we recovered the car, there was some, somewhat corroborative evidence inside. So I'm just wondering about whether the prosecutor's statement in closing, I don't know if you have it available to you or if you're familiar with it, seems to suggest a different understanding at trial, by the prosecutor at least, about what was or wasn't in for the truth.
Sure, I think that's a fair question. I was able to pull up page 86 of the transcript, so I've taken a look at the language the court is referencing. So I take Your Honor's point that it's entirely possible that in commenting on the evidence, the trial AUSA may have been referring to the idea that Mr. Gray may have had these items in his possession just days later. But I think we sort of need to put that in context, right? So I think what we know is that he's arrested about, I guess, a couple days after.
Well, just to be very clear,
Yeah.
I'm less interested in what we might, I mean, I'm not sure we know anything. We just have transcripts where people said things and then maybe things judges found. But I'm interested in your answer to this question. Can you at least be real clear about what things you think were in front of the trial court as a finder of guilt or innocence? So instead of what we might know from the search warrant affidavit, if we think that it gives rise to knowledge, or what other information was, if you could just tell me, what would the trial court have had in front of it for guilt or innocence on the topic you're about to address? That, and if there's other information you want to mention, fine, but just I'd like to be really clear about what's on which side of the ledger as you understand it, about what was evidence of guilt at trial on this issue.
Sure. So I think what's evidence of guilt for a substantive evidence at trial is, one, the physical fruits that was found in the car. Two, the fact that Detective Kaselitz oversaw a transfer of the vehicle from Alexandria to the District of Columbia Department of Forensic Services. And three, that he executed that search on March 14th. I think that's what's before.
I actually think you're underselling your case. You also had the testimony of the detective on cross-examination by the defense lawyer, which brought out all these same facts.
I think that's exactly right, Judge Kravitz. And I sort of wrote down as you were talking about that sort of comes up with the idea that, look, what's good for the goose is good for the gander on this point. And certainly the absence of a firearm found in the car was evidence that trial defense counsel made significant light of, particularly in light of the fact that these other items were present. And so the absence of a gun is probative. The trial court obviously chose not to credit that argument or sort of go along those lines, but certainly by the time cross-examination rolled around, defense counsel made full use of the evidence that was found in the car, and I guess maybe doesn't open the door because they're going second, but certainly renders any error that happened here constitutionally harmless beyond a reasonable doubt. I recognize I'm over my time. I appreciate the court's questions, and if there are no further questions, we ask that the judgment of the Superior Court be affirmed. Thank you.
All right, thank you, counsel. Mr. Winograd, you reserved a couple of minutes for, I think, 3 minutes for rebuttal.
I did, Your Honor. And so very briefly, I'd like to turn to the issue that the court was just discussing with counsel. And that is that in addition to the fact that I think it's actually less than opaque about what the judge thinks is relevant and probative here, because if you go to page 88 of the transcript of the 22nd, of April 22nd, the court says specifically, I've seen enough of the gun and the case and all of that from being shown it in the courtroom. And the trial judge specifically says that she's basically using this evidence and giving it weight.
Well, no, there's no dispute. The judge thought, well, I've seen enough of the gun. I mean, I'm not quite sure what that means. I'm not sure what that means, but there's no question that the trial court admitted evidence that at the time of the execution of the search warrant, the gun case was found. For sure, the trial court admitted that. What is murkier is whether the trial court thought, oh, the reason I'm admitting that is because I've got some evidence about the custody of the car in between, and I'm relying on that for the truth, or whether instead the trial court thought, well, this is a relevant standard. It's a relatively minimal standard. And also if I'm balancing prejudice or prejudicial effect and probative value, I'm going to let the circumstances of the recovery of the gun, even if it's 3 months later, we don't know what happened in between his car, it's relevant. We don't know which of those two things the trial court was doing from anything that I can see that's very explicit. And that's I guess where what I find opaque. And I think, to me, what the point that your opponent raised that I'm most interested in your response to, and it also came up in Judge Kravitz's questions, is if the picture of this was what happened in the government's case is kind of murky. Maybe some of the search warrant information came in, maybe it didn't, maybe it was only for hearsay, but then comes cross, and the defense attorney on cross kind of jumps into it with 2 feet. Clearly eliciting testimony about the circumstances of the possession of the car by the police during the interval. Why doesn't that make any error harmless? The defense chose for strategic reasons when it was very unclear what had happened already, instead of trying to be really clear about, oh, no, I don't want to get into this, kind of jumps right in and tries to make tactical advantage of it. Why doesn't that leave you with what the record that was created on cross, which does end up then providing some circumstantial information about how the car was being treated during the period when it was in the possession of the Alexandria, or I think it's Alexandria police?
I would posit, to your honor, because as your honor says, we can't tell from the transcript, it's too opaque to know what the judge was weighing. I would posit that in the courtroom, Mr. Johnson believed what I believe, that this was being admitted all for the truth of the matter asserted. And once that evidence was there, he had no choice but to try and rebut it on cross-examination. That strategy would have been quite different, or could have been quite different, had in fact that evidence not been there, or the judge had been clear that she was not giving it great weight. And that is why the court cannot say for certain that this evidence, which I believe still to be error, did not sway the finder of fact.
Here's another question on the harmlessness issue. The relevance of the items that were seized from the car was that those items, the presence of those items in the car corroborated the complaining witness's allegation that the defendant had a gun in the car that he pointed at her. Correct?
That's correct. That was where I was going.
Okay. So your client, in addition to the cross-examination of the detective, your client also testified that he was a security guard who often carried a gun in his car. He denied having one on that day, but he testified that he often carried a gun in his car. Seems to me that is precisely the equivalent corroboration of the complaining witness's testimony, the complaining witness's allegation, and maybe even a stronger corroboration than the presence of these gun-related items in his car a few days after the incident. I mean, in other words, the presence of a gun box in his car 3 days after the incident didn't do any more, and probably did less to corroborate the complainant's allegation than your client's own testimony in his case that, yes, I own a gun, I use one for work, and I often carry it in my car. All of that is just corroboration of what she said he did. And given all that, this seems to be so obviously harmless.
Your Honor, it can't
if there
be
was
harmless.
error at all.
I'm sorry, say that again, Your Honor. I apologize.
I said if there was error at all, I think you have a really steep climb here on harmlessness.
I read your point, Your Honor, and I would say that the decision to testify, this court cannot be convinced that decision was not made because of the evidence that was let in, and he would then have to explain it. Just like Mr. Johnson had to cross on it, Mr. Gray was in a position to explain what was there. Otherwise, we have this evidence that was admitted improperly that corroborates what the alleged victim was saying. And so he has to get on the stand and do something about it. He can't just rely.
It's utterly speculative to think that. For us, isn't it? I mean, there's not like the lawyer said, "Oh, Judge, my client wouldn't have testified, but he's going to testify because you erroneously allowed this evidence in. And I wouldn't have cross-examined the detective on this point, but I have to because you erroneously let the evidence in."
To be fair, Your Honor, all harmless error is speculative. The standard for harmless error is whether or not this court can be fairly certain that the improperly admitted evidence did not sway the trial court. That in of itself is the standard is speculative. So
as you, is it apropos of an aspect of Judge Kravitz's question? It's also the case, isn't it, that your client had admitted to owning a firearm in the statement to the police officer that the government had already introduced. And so that kind of corroboration is not contingent on your client's later testimony. Is that right?
That is correct, Your Honor. That's correct.
And is it also, if we're trying to figure out how likely it is that your client would have had to testify anyway, that also is kind of germane, because if he's got a statement, he's got the statement to the police where, it's sort of as it came. I mean, I haven't yet viewed it. It's now available to us, but as it's described in the briefs, it's I have a gun. I don't remember about this particular possible argument, but people piss me off all the time. I think one might, if we're trying to infer why your client testified, I think the need to respond to that evidence would be a much more likely inference than the kind of murky issues relating to exactly how much of the circumstantial information about the state of the car and the period in between its seizure and its search would be, that seems like it would be a very distant second as far as what kind of inferences you would draw.
I respectfully disagree, Your Honor. I think that owning a gun, and when he makes the statement to the detective that he doesn't remember this particular incident, the fact that he owns a gun, he's not as clear about carrying it in the car as he is on direct testimony, which is directly to rebut the evidence found in the car that was improperly admitted. I know I'm over my time, Your Honor. I just want to raise one point about Judge Blacksburn Rigsby's questions to government counsel, if I may, if that would be allowed. The question about whether, if you know that it's a real gun, can the threat stand? My answer to that, if he cannot be convicted on the gun charge because you don't know if it's a real gun, can the threat stand? I think in this case they cannot, because the complainant's only discussion of a threat was the pointing of the gun. It's on page 21 of the transcript on the 17th. So if there's no gun, and if she's wrong about the gun, he has to have an intent to threaten her with something. And if we don't know what this object in his hand is, how can he be actually making it a threat? She doesn't say that he told her, I'm going to blow your head off, or something similar that we could obviously construe as a threat under the Carroll standard. And that's the last point I'd like to make. And I would ask that the judgment of the Superior Court be reversed and this case be remanded for a new trial.
All right, thank you. We'd like to thank both counsel for your briefs and arguments in the case today, and we will take the matter under advisement. And at this time, I believe we stand adjourned, and counsel, you're free to exit our virtual courtroom.
Thank you,
Your Honors. Have a good day.
This court is now adjourned.